This is Local 15 Law Call.
And hello everyone, welcome to Local 15 Law Call. It's a show where we discuss a different legal topic each week. Then we take your legal questions live on the air. And tonight, we're talking about domestic issues with Love and the Law. The phone lines are open, so if you have a question, we invite you to give us a call, 877-622-1548. But first, let's check out the docket over the next several weeks, what we'll be talking about here. Next week, it will be hurt on the job, workman's comp and the like. And then on the 3rd of March, it'll be taxes and the laws. We get close to tax day in mid-April. March 10th, we'll be talking about starting a business. On the panel tonight, as he is each and every Sunday night, from the law firm of Island & Ritchie, attorney Bill Island, and we hope you had a happy Valentine's Day.
Right.
But if you didn't, we are here for you.
Right. Just in case you did not, then we've got the perfect topic for you.
But we're taking everything.
Right.
It doesn't have to be divorce, child custody. If you have something along these lines, it might be, we've been together 20 years. Are we common law? Those sort of questions.
Absolutely. We've been doing this show now going on 7 years, and this is probably our most popular topic because there is not a single person sitting out there who has not been affected in some way, shape, or form by divorce or child custody, child support. If you yourself have not been divorced, which most adults, most surveys show that 50% of all marriages end up in divorce. So if you yourself have not been divorced, chances are your parents or your brother or your sister or somebody close to you has gone through this. And there are so many different aspects to a divorce. The simple divorce is when you're 23 years old, no kids, and you own no assets. You get divorced and just call it a day. But especially once you have a child, and if you have any assets, things get complicated, and you need to know what your rights are. And so, any kind of domestic question you have for us tonight, give us a call. And with us tonight, who is an expert, Shane Taylor. This is what he does. First time on the show, and we're extremely happy to have him tonight.
Thank you for having me. I appreciate it.
Good to be here. Glad you're here. And now I'll tell you what, why don't we start off fault, no fault. You hear that so much of the time. Maybe people don't know, maybe they do, but talk about that when you're talking about a divorce.
Absolutely.
In a fault case versus a no fault.
Alabama is a no fault state, as most states are now. You can cite incompatibility, irreconcilable differences. You can also cite fault, though it's more rare. More often than not, people just cite irreconcilable differences in divorce now rather than issues such as adultery, abuse, etc.
Yeah, used to, we've all seen movies where, somebody says, I want a divorce, and the other party says, well, I'm not giving you a divorce. Well, that may have been the case back in the day, but it's certainly not the case now. And that's one thing that kind of Shane was alluding to. Used to you would have to show and prove your grounds for why you needed a divorce. Was there adultery? Was there abuse? Now, like you said, irreconcilable differences. That's really all you have to state. That just says, hey, I can't get along with this other person, and the judge is going to grant that divorce. There's no holding your partner in that marriage if they don't want to be in that marriage.
But they can make it tougher, I suppose,
they can
on
make
you
it more
and
difficult.
drag things out. And do you see that often?
We see that quite often, and like I tell our clients, you're going to get a divorce. It's just a question of how much effort they're going to make us put into it. It's usually in everyone's best interest to do an uncontested divorce, if at all possible. If you have to, in some cases you do have to go all the way through trial, but more often than not, it's in everyone's best interest to either do an uncontested divorce or attempt to reach some type of settlement prior to trial, such as through mediation or just negotiation between attorneys.
Yeah.
All right, let's get right to the phone calls. As usual, we expect to have quite a few callers tonight. First up, Tanya, who's calling from Pensacola. Go ahead, Tanya.
Hey, Tanya.
Hi, I'm calling because my question is, I was involved in a relationship that would be considered common law. This was like 13 years ago, and we had a child out of wedlock. So some things prevented me from going to our court hearings in relation to our child because a police officer said that we had a domestic violence relationship, and some things prevented me from going. So in the meantime, I've been involved in her life through, several different needs, but nothing physical. Now that I am able to do so, I need to find out how to go about, having more parental involvement aside from phone calls, letters, things in that nature. I want to do something, physically,
So
because
Tanya-
this is my child.
Tanya, does the father have custody of the child? I take it.
Yeah,
Okay.
that it started off as a thing through the court to where I needed to go and set up visitations, third-party visitation type, but I wasn't able to do it. I ended up having to actually leave the state, and yes, it has been a while,
Okay.
but now that I'm here,
Okay.
like I said, I want to stop.
Did you get all of that?
I'm
There's
having
a
some
lot to-
bad audio
Yeah.
here.
I mean, in a nutshell, she stated that she was what she called a common law situation, which I know we'll get into that later, but she was with her husband or her boyfriend for 13 years, had a child out of wedlock. The father got the custody of the child, and now she's only had limited contact with the child, but now she wants to know what she can do to try to gain more access to that child.
Okay. I don't know whether you've had an order issued by a court regarding visitation, but if you have not, I would recommend that you get an attorney, file a petition to get some visitation with the child. I'm assuming there has been something, some order out there. You can always file a petition to modify custody and go back to court, revisit that issue, and once again, that's something that's more often resolved through agreement prior to trial.
Yeah, these things, it's a fluid situation. And so just because if your contact or your availability is limited at this point, even, as Shane was alluding to, by the court, it doesn't necessarily mean that that's a death sentence and that is the end-all, be-all. Like I was mentioning, it's fluid. You can always, things have a tendency to change, and you can petition the judge to say, look, I'm back in town now. Whatever issues we had before, they're behind us. I want more, contact and and be more of a part of that child's life, and the judge will
least
have
consider
to
it.
yeah, and especially if you can get your ex-spouse to kind of go along with it, but it's certainly not out of the question.
All right.
And if I may, it's even under certain circumstances possible to have the prior order of custody amended so that you could obtain primary physical custody of the child.
Right.
Yeah, bottom line, never give up. If
Right.
you have an interest in being in that child's life, keep after it. All right, he's calling from Mobile. Bob, you're up next. Go ahead.
Hey, Bob.
Thanks for taking my call.
Yes, sir.
I had kind of a complex type of situation. I originally got a divorce in Mississippi maybe 12 years ago, and I was paying child support, and my ex disappeared with my kids. So my son knocked on my mother's door a couple of years ago, and there was a 7-year gap in between the two time frames. Since that time, I moved to a different state and resided for 7 years in a different state after that. And I have paid child support back, for the 7 years that they weren't in my life. The DHS office that got my receipts says that a court of law has to give me credit for that cash and those receipts. The state I reside in now, it has a better record and a fair and more impartial system than Mississippi does. Who has jurisdiction, and can I go to a court hearing in the state I reside in now?
Wow. Shane, I told you before the show that we're probably not going to have very many complicated questions.
I was going to say, this
so
would
I'm
be one of
sorry
them.
about that. But
It's okay. It's going to depend on the law in the particular state you're in. You could always bring the case in the court of original jurisdiction still. If I'm to understand you correctly, the mother and the children may still reside in that state. What I would recommend you do is consult a local attorney in the state that you're in and seek some guidance from them, and they should be able to tell you where the action should most properly be pursued.
Yeah, Bob, just like Shane said, bottom line is, you live in Alabama now. Go see a lawyer. here in Alabama, and they'll be honest with you and tell you as far as which state and which venue you need to bring this in, because if you bring an action here in Alabama but the proper venue is in Mississippi, then your ex and their lawyer can have it removed and brought back over to the proper venue. So before you go through all that rigmarole as far as filing something, I would it would be in your best interest to go see an expert here in Mobile or here in Alabama to see which area you need to go to.
All right, well, we are talking about domestic issues here on Local 15 Law Call. It is Loving the Law. We'll be right back after this break. Stick around.